Is it possible to conduct a hearing based on written statements only? In other words, not to have a hearing with chairperson, initiator, witnesses, all that. Is it possible? Well, if you look at the Code of Good Practice on dismissal, Clause 4, all it says is there must be an investigation. This need not be a formal inquiry. There's nothing that says that you have to have a meeting with a whole lot of people present. So in principle, it is possible for the hearing to be conducted by way of written statements only. Take this example. A report is made to me, a line manager, that an employee has been found in possession of company property for which he had no authorization. I speak to the person who makes the report and I say, can you please give me a written statement? And the person gives me a written statement with all the details. I can even sit to the person, ask questions, and write the statement. Say, well, just for the record, just your name, your department, employee number if necessary, what day were we talking about, who are the people involved, what did you observe? And I make the notes, and I ask questions. I say, are you certain that the employee that you saw, are you certain that the person didn't have authorization? Then I give this to the person and I say, there's the statement, please read it. If you're happy, sign it. If there's anything to be added, let me know and then we'll add it. So this complainant now signs this. I then call the employee in. I say, Mary, I've received this complaint from your supervisor or from another employee, could be another employee. I'm Mary's manager. Do you have any immediate response to this? No, she said. I say, well, take a day or two to look through this and please give me your written response. If there are any other people whom you think can throw some light on this, please let them come to me so I can ask them for their written statements as well. So off goes Mary. 3 days later, she comes back and she gives me a written statement in which she denies everything. I'll then say, okay, Mary, please come to my office tomorrow. Joe, please come to my office. We have a problem here. Joe, you accused Mary. Mary's denying. Let's talk about this. Well, Joe, what did you see? Joe says everything that he wants to say. Mary, do you have any questions? Mary asks some questions, but she doesn't deny the essence of what was said. Say, Joe, do you have any questions of Mary? Joe asks a few questions. I say, Mary, I've got a few questions. How do you explain this? You don't seem to have any dispute with what Joe said about this. My sense, Mary, is that Joe's allegations, I think, are more probably true than yours. So, Mary, I'm disappointed in you. You have removed company property without permission. I'm finding you guilty. Is there anything you'd like to say to me now regarding sanction? If not, well, let me have something in writing by tomorrow, close of business, about why your services should not be terminated. Is there anything wrong with that? In principle, no. The only time you shouldn't do that is if you've got an internal procedure that requires a different kind of hearing, a formal hearing with all sorts of characters present. But that demonstrates just how flexible our law is. Ultimately, it's about having the right to state your case for the employee and the chairperson making a decision objectively on the facts.